How do police charge persons in Queensland with criminal offences? In Queensland, there are three ways a person can be charged with a criminal offence. The first one is an arrest. Police physically take you to the watch house where they formally charge you with the offence. You will either be remanded in custody or given bail to appear in a magistrates court. The second way is a notice to appear. Police will give you a small piece of paper called a notice to appear. Police will write out the notice to appear and give it to you on the spot or after they've taken you to a police station. The notice to appear is later sent to the prosecution so it can be given to the court. Now there's various things the notice to appear should include. This is 1, a description of the offence you're charged with. 2, the actual magistrates court where you must appear to answer the charge. 3, the date you must appear in the magistrates court. If you're issued with a notice to appear, you must appear in court on the date on the notice. And this is even if you have a lawyer acting for you. In some situations, if you don't appear, a bail act warrant will be issued for your arrest. In some circumstances, if you don't turn up, they can actually deal with your matter in your absence and you won't have an opportunity to say anything. The third way is a summons. A summons is a document commanding a person to attend a court at a time and place. It's not common for people to be issued summons. The Queensland Police Service Operations and Procedures Manual tells police officers to only use a summons if it's not practical for them to issue a notice to appear. Now there's 3 parts to the summons. 1's the complaint. This is the information supporting the issuing of the summons. 2, the summons itself, the person who issued the summons, the time and the court where the person must attend. The oath of service, that's the person who gave the summons to the person named in it must swear on oath before a justice of the peace that it was given to the person named in it. Now, what are the most common ways persons are charged with criminal offences in Queensland? The most common ways are either the issuing of a notice to appear by police or alternatively being arrested by police. They're the most common ways. Police don't generally use a summons. Now, how long do police have to lay criminal charges in Queensland? In Queensland, the time police have to charge you with a criminal offence depends on what type of offence it is. If the offence is what's called a simple offence, the police have 12 months from the date of the offence in which to charge you. However, if the police charge a person with an indictable offence and that's subsequently discontinued, the police can charge a person with a simple offence within 2 years from the date of the offence. So what's a simple offence? The Justices Act in Queensland defines a simple offence as this: means any offence, indictable or not, punishable on summary conviction before a magistrates court, by fine, imprisonment or otherwise. So this means if the offence you're charged with must be dealt with in the magistrates court, then the police has 12 months from the date of the offence to charge you with it. If the offence is an offence required by law to be dealt with in the District or Supreme Court, then there's no limitation of when police can charge you with the offence. And this is why there are historical sex matters that occur many years ago that are subsequently prosecuted by police. And this is why they can do that, because there is no limitation.